At our law firm, we represent passengers that are injured aboard tour boats and charter boats. General maritime law governs accidents that occur to passengers. Think of the whale watching trip in the San Juan Islands. Maybe it's a dinner cruise in Puget Sound, or one of many of the fishing charters we have out of our coastal cities. If an individual suffers an injury aboard one of these boats for hire, their claim is governed by general maritime law. The vessel owner, or the tour boat operator, has a duty of care. Under the kermarec standard, this is known as the duty of reasonable care under the circumstances. A passenger that suffers an injury on one of these tour boat or sightseeing tours has a negligence cause of action under the general maritime law. In order to establish a successful claim, the accident victim will show that the tour boat had a duty of reasonable care under the circumstances, and that duty was breached by an act of negligence, and that the negligence caused the injury to the passenger. Tour boat operators have been known to go out into seas in inclement weather, and as a result, they go out or they don't heed weather warnings. And a passenger suffers an injury on one of these tours due to the violent motion of the boat. These are smaller boats typically. For passengers that suffer injury on a tour boat, it is imperative that they report their injury to the vessel's crew to document the claim, and they may need to fill out an accident report. If the injury is substantial enough, the tour boat operator has an obligation to take you, the injured passenger, to shore for further treatment. What many tour boat passengers don't know is that their ticket, their cruise ticket, their sightseeing boat ticket, is actually a maritime contract, known as a contract of passage. The passenger's rights under general maritime law may be limited under these contracts. The ticket may require the injured passenger to bring suit in a particular venue or forum. A ticket for a dinner cruise out of Seattle will likely require any litigation arising from the shipboard accident to take place in Seattle. The tickets will likely also reduce the time period in which an accident victim has time to vindicate their rights in a lawsuit. By federal statute, all claims by passengers against common carriers, such as cruise lines or even these dinner boat cruises, must be brought within 3 years. But that 3-year period is often further reduced by the contract of passage, the passenger's ticket, requiring in as little as 6 months. The passenger must file a written notice of claim and provide that to the tour boat operator and bring the lawsuit within 1 year. So despite the constitutional grant of the Savings and Suitors Clause, allowing maritime claims to be brought in both state and federal courts, these sightseeing tickets for tour boats may require that suit be brought in federal court. It's important as soon as possible after an accident on a tour boat or a sightseeing trip that you consult with an experienced maritime counsel to help you avoid these pitfalls from the fine print that may be located in your cruise ticket.